Al, I'll go ahead and hand it off to you if you want to go ahead and start.
Okay. First thing you're going to have to do has everybody been invited in?
Everyone should be in. We'll start with roll call, and just a heads up for our 3 Construction Board of Appeals members, if you'll see on the screen, to comply with the township's remote participation policy, if each of you could please say that you're here attending remotely, and then the location, which is either the county, city, township, or village and state from which you're attending the meeting, we can get you on the record. So we'll go ahead and start with Chuck Carlson. Chuck, can you go ahead and unmute for us?
I'm in Fenville, Michigan.
Okay, thank you. And then Bob Firmus.
I'm in Saugatuck, Michigan.
Thank you. And then Jason Dedek.
Yeah, remote from Saugatuck.
Thank you. Just a few more Zoom instructions, as I know most of us are still getting used to conducting meetings this way. Please try to keep yourself muted unless you are either speaking during public comment, you're the applicant at the appropriate time, or you're a member of staff or the construction board. If you do need to unmute, you should be able to click the unmute button. If you're participating by phone, *6 for most phones is the way to mute and unmute. Otherwise, we've got a relatively small group, but please do your best to not speak over each other. Please announce yourself before speaking, and then otherwise the meeting will be recorded. Other than that, before we go any further, are there any questions from anyone about Zoom or the Zoom instructions? Okay, if not, Al, I'll turn it back over to you with the approval of the agenda.
Okay, yeah, if the members of the group will look at the agenda page and determine whether or not they want to change anything or add anything or remove anything, or, okay? Does anybody want to add anything? This is for the 3 members of the board.
I'm all good with it, Al.
Okay. Bob?
I'm okay with it as well.
Okay. Chuck?
I'm good as well, Al.
Okay, then somebody should make a motion to approve the agenda and to ratify the procedures for public precipitation and meeting conducted as described in the notice of public meetings via conference.
Jason will move to approve the agenda and to ratify the procedures for public participation and meeting conduct as described in the notice of public meeting via video conference.
Okay. The other thing we have to do now for procedural problem is to elect a chair and a vice chair among the 3 of you. So talk it over and see who wants to nominate who to be chairman and vice chairman. First, the chairman.
Gentlemen, I'm going to interrupt quickly. Can we do a vote on the approval of the agenda, please?
Yeah.
So if we go ahead and do this one, so we'll do it by roll call vote. So Jason Dedek.
Approve. Yeah, aye.
Yes or no is appropriate.
Yes.
Thank you. Chuck Carlson.
Yes.
Thank you. Bob Firmus.
Yes.
Thank you. The agenda's been approved.
Okay, motion carries.
Yes. And then our next item of business will be public comments and correspondence. Is there anyone from the public who would like to speak before we move on to new business, which is electing a chair and vice chair and to review the application for a variance from the construction code? If you would like to speak during public comment, please unmute yourself and state your name, and we'll go ahead and go one at a time. If you are the applicant, we will give you a chance to speak on your application when we get to that agenda item. You're welcome to speak during public comment, but you will have a specific time as well. I am not seeing anyone looking to speak one last time. Is there anyone who would like to unmute themselves or raise their hand or do some kind of acknowledgement that they'd like to speak during public comment? Okay, members of the construction board, I don't see anyone. So if you would like to move on to new business.
That would be the election of the chair and the vice chair.
So this is Charles Carlson. I elect Jason Dedek as chair.
Thanks, Chuck. I was going to actually elect Bob.
And you nominate.
Nominate Bob. I would be happy to be vice. I was just the head of a chair and I need a little bit of break being head of the chair for a minute. I'd be happy to be vice if that nomination came my way.
Well, somebody has to nominate a chair.
All right, I'll nominate Bob then for the chair.
Yeah.
Guys are too nice.
Is there a second to that?
I'll second that.
Okay.
And I'll nominate Jason Dedek as vice.
Well, let's do it one at a time, gentlemen. All right. Who's going to nominate? Anybody else? So
I'll second the nomination. I'm sorry, I'm not used to this.
okay. Then have a vote for the chairman first. Between the three of you.
I can do a roll call vote again. We'll start with Chuck Carlson,
Yes.
Jason Dedek,
Yes.
Robert Firmus.
Yes,
Congratulations, you're the chair.
thank you.
Now the nominations for vice chair.
Jason Dedek for vice chair. This is Charles Carlson nominating Jason Dedek for vice chair.
Is there a second to the nomination?
I'll second that. Bob Firmus, I'll second that.
Okay. Take your vote.
Bob Firmus,
Yes,
Jason Dedek,
Yes.
Charles Carlson.
Yes.
Thank you. Congratulations, you're the vice chair.
Awesome.
get you a
Right,
trophy.
the next order of business is a hearing in regards to Josie and Tyler Bodish for variance from the construction code. The chair has to open the meeting and then ask the applicant to tell us why they want to be before this board and any other information they may have. So
Okay. I'm Bob Firmus. I
open the hearing.
the hearing for Josie and Tyler Bodish for their construction code application variance at, what is the address?
3487.
3487 66th Street.
Thank you. This is Aaron Phelps. I'm the attorney for the Bodish family. Can you hear me fine? Well, I'm going to, I'll proceed. Obviously, they're there. You can see them on the screen. I'll be presenting the information that's the subject of the appeal. And if it's all right, I'm going to share my screen, which I think will be hopefully be helpful.
Yep, give me 1 second.
Okay.
You should be able to share your screen now, Mr. Phelps.
All right, can you see that?
Yes.
All right. I'm assuming if somebody has any problem seeing something, but let me know. All right, as I said, Aaron Phelps of Barnum Law Firm on behalf of the Bodish family, we've filed this appeal to this Construction Board of Appeals. And what I wanted to do to open with is address really a fundamental issue, which is the jurisdiction and role that this construction board plays in this, because in the materials that were submitted on behalf of the township, it was stated that this is not the appropriate forum for applicants to assert the arguments raised in their application. And obviously, if the board doesn't even believe that it's their role to weigh in on this, then this would be a pretty fruitless appeal. And that would also be contrary to Michigan statutes. And so I'm putting those up in front of you so you can see them, make notation, look at them later, whatever you wish. But what's on the screen is Section 11 of the Construction Code Act. And the building permit section, which is what we're concerned with today, clearly states that the enforcing agency shall examine an application for a building permit. And if the application conforms to the act, the code, and the requirements of other applicable laws and ordinances, the enforcing agency shall approve the application and issue the permit. That we have submitted a permit application. The enforcing agency under that statute is to be determined by the local body, in this case, of course, Saugatuck Township. And now what's on the screen is Section 826 of the ordinances, which clearly states that pursuant to the Construction Act, the building official of the township is designated as the enforcing agency to discharge the responsibilities of the township under the act. I put that out there to make it clear that while Saugatuck Township is part of a fire district, a multi-municipality fire district, the fire district is not the building official. The fire district is not the enforcing agency under the construction code. The fire official and the fire district does not issue building permits. Those always remain statutorily the responsibility of the township. And while the township is certainly free to ask for input from the fire district or anyone else, it ultimately bears responsibility for issuing those permits. And then that brings us to this body, which is Section 14 of the Construction Code Act, a Construction Board of Appeals. This body is actually statutorily mandated to exist as an appeal from the township. And I think it interesting that statutorily the members of the Board of Appeals must be qualified by experience or training to perform the duties of members of the Board of Appeals. In other words, have some construction-related experience or training. Why? Because this board is expected to weigh in on the substantive matter. This is not a deferential review. It is not a rubber stamp of what's been done. The board is intended to operate independently and statutorily, independently of the township, and render its own decision, and the members are expected to have this expertise and training that enables them to give an independent review and independent look. This appeal comes under the second highlighted portion. If an enforcing agency refuses to grant an application for a building permit, or if the enforcing agency makes any other decision pursuant or related to this act or the code, an interested person or the person's agent may appeal in writing to the Board of Appeals. And that's exactly what we've done. A permit was applied for, it was not approved, and therefore it was subject to this appeal. One last provision I want to call to the board's attention is Section 15. This provides for specific variance from the code. After a public hearing, the Board of Appeals may grant a specific variance to a substantive requirement of the code if the literal application of the substantive requirement would result in an exceptional practical difficulty to the applicant, or if both of the following requirements are satisfied, and there being provisions A and B, the performance of the particular item or part of the building or structure with respect to which the variance is granted shall be adequate for its intended use and shall not substantially deviate from performance required by the code of that particular item or part for the health, safety, and welfare of the people of the state. That being Section A. And Section B, the specific condition justifying the variance shall be neither so general nor recurrent in nature as to make an amendment of the code with respect to the condition reasonably practical or desirable. I raise that because, again, calling into question the role of the Construction Board of Appeals, the jurisdiction in the context of this case, not only is it an independent body that should weigh in on the substantive issues, but you actually have statutory authority to grant variance. And for the reasons I will come to, while we don't think a variance is necessary because there's no appropriate requirement that requires municipal water in the first instance, if there was, it would certainly be our request and the board's within the board's authority to grant a variance. So with that that framework in mind, I proceed to the substantive matter before the board. And I want to start there with making clear that this is a single family residence. This particular property was part of a larger parcel a couple of years ago. It was the subject of a land division under the Land Division Act. That land division application was submitted to the township. The land division was approved, really without incident, and this parcel was thereby created. It was not and is not part of any other sort of developmental model. It's not a PUD, it's not a site condo, it's not a plat. This is a straightforward single family lot of record in the township created by a land division, and there was absolutely no requirement, no contingency imposed by the township at any point in time that municipal water be extended to this parcel, this lot, in order for construction to take place. The Bodishes are a family. You see them on your screen. They purchased this lot earlier in 2020. They submitted an application. They hired a builder. They intended to proceed with construction in the fall of 2020. They submitted all of the materials, their builder did, on their behalf that are necessary to obtain a building permit. Everything was deemed appropriate, except the materials were submitted to the fire district for review, and the fire district, to my client's surprise, came back with a series of requirements, and hopefully the screen has adopted a second document I'll put in front of you for the record. These are simply pages that are out of the packet that you received, and I believe that all of those pages are sequentially numbered. This is page 38 of the PDF if you've got the electronic version. And actually, I'll jump up a little bit. You'll see this was the August 2020 determination from the Saugatuck Township Fire District. It indicates it's to Benchmark Design Studio. That's really the builder that the Bodishes hired. And you'll see the number on paragraph 12 on page 38 make more sense in a little bit, but as an initial matter, you'll note that there's an acknowledgement of, I suppose, the obvious, that this is a single family residence. And at least in regard to paragraph 12, it's noted that there's a single family dwelling exemption. However, paragraphs 13, 14, 15, 16 go on to set forth a series of requirements, And what they boil down to are the installation of fire hydrants and a water main to service this property. And since August of 2020, there have been many communications with the fire district and the township in an effort to unravel what is going on. But the long and short of it is the fire district has opined that this lot and the Bodishes should pay to have municipal water extended to the lot, pay for the installation of fire hydrants at their expense prior to the issuance of a building permit. And the township has evidently adopted that view for itself and is refusing to issue the building permit unless and until municipal water and fire hydrants are installed. I don't have the exact figure, but this lot was maybe in the $100,000 range of expense, and we're talking about hundreds of thousands of dollars to extend municipal water, again, solely at this one lot owner's expense. This requirement is, we're told, comes from the International Fire Code, which has been adopted by Saugatuck Township. You know, you'll see in the packet of materials the submission by the township, the attorney memorandum. There's very little, if any, discussion about the International Fire Code. Instead, there's the request that you simply defer to the fire district and not consider it at all. But if you look at the fire code, you'll see it's a code. It is not intended to be a document, a municipal planning document. It is not intended to set forth where in the township municipal water is supposed to be extended to. It's not intended to say which residences get it, who pays for it. I mean, that is not what a fire code does. The township has tools at its disposal when there are developments, when it's asked to approve PUD or similar things, and there's often a negotiation between a developer and a township, and that may involve the extension of certain utilities and where they go and how they're installed, et cetera, et cetera. That's not what's happening here. This is a family who's trying to build their house on a lot that they bought without any such knowledge that these sorts of requirements would be imposed, and they're being imposed under a generalized authority that the fire code, quote unquote, requires it, even though, of course, the fire code does not purport to require the extension of municipal water and fire hydrants to every corner of the township. There's, if there were any confusion about that, you'd need only look at what does the fire district do in other instances. Of course, that was my first question is, well, clearly, I live in a rural township myself, and we don't have fire hydrants really anywhere. Are we to understand that the fire code requires every residence in the township that's constructed to have municipal water and fire hydrants? Well, this on the screen is part of your packet. It's page 40, issued by the fire district July 23rd, 2020, which I'll note is barely a month prior to the issuance of the determination for the Bodish's property, which is the subject of this appeal. This one relates to a property 6573 Heron Bay in Saugatuck. New residence, site plan review number 1 for new residents. If you go to page 41 of the packet, which has items 13, 14, 15, 16, those are the parallel provisions in which the Bodishes are told they're required to extend municipal water. But in this instance, the fire district states that none of those are applicable because there's a single family dwelling exemption. Now, you'll notice there's no citation after single family dwelling exemption. I cannot find any express single family dwelling exemption anywhere in the fire code. None is cited to here. You'll note that this phrase single-family dwelling exemption was also used in the Bowdish's determination, although not with regard to these specific, with regard to 12, not 13, 14, 15, 16. So ostensibly, we have the fire district applying what is a neutral international fire code. It's not designed or it doesn't speak to any particular part of any particular township. And the interpretation of the fire district is that the fire code requires fire hydrants. Well, if it does, then it must require them from everyone internationally. Everyone who's adopted the International Fire Code must be required to have municipal water and fire hydrants under the interpretation that's been submitted by the fire district. Yet within the township itself, that is not how it works. Evidently, the fire district makes independent, subjective judgments about which homes will have municipal water and which ones won't. And it's not based on any objective criteria, any particular code section. When it's a single family dwelling that is apparently deemed not to need that level of fire protection for whatever reason, they're given this arbitrary exemption. And in my client's situation, they were not given that exemption. The question then logically arises, well, why is that? And what we have been told by the fire district is that, well, this is a development. And so the judgment's made that since it's a quote unquote development, it will be required to have municipal water. As I said at the beginning, that is just factually not true. None of the materials that you've been submitted have a stitch of evidence that this is part of a development. It is what I said it was. It's a lot of record that's the result of a land division that occurred without any contingency or requirement from the township. It is in no way, there's no common developer. The Bowdishes own this lot. They've hired a builder. They're the developer of their lot, but they are not a developer of a larger unit or a larger group of lots or dwellings. And incidentally, numerous of those lots that are on this street, they have been sold to independent third-party persons, some of whom have submitted their own building permit requests. And so unfortunately, I guess for the Bowdishes, they happen to be the first ones that have to deal with this issue, but they're clearly not going to be the last if the township doesn't change its position, because people simply cannot buy individual lots of record that are clearly entitled to have homes built on them and then be told that they must incur hundreds of thousands of dollars of expense extending public utilities in order to have the permit to which they're entitled issued. The fire code is simply not a vehicle for the township or anyone else determining where within the township municipal water or other public utilities should be extended. And that leads us back really to the point of beginning, which is the jurisdiction of this panel and what exactly it is we're asking. I think it's clear when you consider the material and what I've shared with you today that there's been an overreach, that the idea that we can use the building code, and in this case the fire code, as a way of leveraging a resident, leveraging a property owner to extend a public utility is not proper. It's not what the codes are for. The township certainly can make decisions about where it wants its utilities, and there are appropriate means and vehicles and ordinances and other things to accomplish that. But using the building code, fire code to achieve those ends is clearly an overreach. And this board would be correct to make the determination that the requirements imposed exceed the authority of the township, and that the permit should issue as requested. Alternatively, the board has the authority to grant a variance. And if somehow the board interprets the fire code as actually requiring everyone to have municipal water and fire hydrants, then there ought to be a variance granted because of the obvious impracticability of doing that. And clearly, you can have homes all throughout the township and all throughout the state do not have fire hydrants, and they are perfectly safe. People raise their families in them, and there's no practical or legal reason why that should be imposed. So I'm happy to entertain any questions, but our request is that this board grant the appeal that's been submitted and instruct the township to issue the building permit as requested and without the requirements imposed by the fire district. Thank you.
Thank you, Mr. Phelps. Al, I'll turn it back over to you.
Okay. Does any member have any questions of the attorney or the Bodishes?
I don't. This is Chuck Carlson. I don't have any questions.
Speaking for myself as the building official, this application was given to Michigan Township Services because I was at a leave of absence from August 4th all the way to November 24th. And consequently, I was unaware of this entire situation until I came back. I do have another application from Mike Scapp Builder in order to build another house within those same lots that the fire department has disallowed and disapproved. Obviously, this is a dispute between the fire department and the gentleman, Mr. Van Horn, and consequently, it's precipitated out where individual people, the township, as well as other people, are going to be sacrificing issues because of that. In my case, I sympathize with the Bodishes, and I wish I could write the permit. But my hands have been tied by the township in that respect because of the fact that it's a prerequisite, just like the health department is a prerequisite, just like the road commission driveway permit is a prerequisite. And if all the prerequisites are not affirmative, then I don't issue the permit. And that's wherein lies this problem. Several years ago, when the township withdrew a portion of the fire code for single-family residences, we were allowed to write permits through the zoning administrator without going through the process of the fire department. So that's the problem, is not just involving writing a permit, it's involving the fire department and disputes that have been ongoing with contractors and also homeowners and also residents of the township. So my position is that I'd love to write them a permit tomorrow. And the person that also submitted one for the lot 10 over there. What about our attorney? He has a memorandum, his memorandum. Is he here?
Yes, I'm here. Hold on,
Okay.
let me mute.
All right, that comes. Would you like to address those issues that were brought up by the Vodish's attorney?
Sure, I can speak to this and explain our position as a township staff a little bit better. So to kind of take a global view of this, Mr. Phelps cited several provisions of the state law, which is the Michigan Single State Construction Code Act. And that act establishes a statewide construction code that applies across all municipalities. And it consists of, I think, 4 or 5 separate codes promulgated by the International Code Council. Those are the building code, the residential code, the plumbing code, the electrical code, and maybe one more I'm forgetting. But notably, it does not include the International Fire Code. The International Fire Code is a code that municipalities are allowed to adopt, not required to adopt. The township has adopted it through one of its ordinances. It's adopted it basically in full. And in doing that, it specifically deferred enforcement, or I guess delegated enforcement of that code to the fire district. And it appoints the fire chief Janik, as the township's fire code official, as opposed to the building department and Mr. Ellingson. And it also sets up a separate appeal board by ordinance using the international code model, which is basically a body within the fire district called the Fire Appeals Board that hears appeals from determinations made by Chief Janik. So all of that to say that the provisions that Mr. Phelps were referring to are really referring to appeals from building code or state construction code provisions. It specifically cited a number of provisions in the Code Act that refer to the code. But if you look in the state law as to how it defines the code, it defines it in a way that does not include the International Fire Code. And so that's basically the reason why we don't believe this board is the appropriate board to be making these arguments. These arguments all pertain to interpretations of the fire code, which under township ordinances are enforced by the fire district and have an appeal to the Fire Board of Appeals as opposed to this body. And notably, the Bodishes have taken an appeal to the Fire Board of Appeals that I believe is scheduled to be heard this evening. I think at least an initial hearing is scheduled for 5 o'clock today. So they're perfectly welcome to make these types of fairness arguments to that body. We just don't believe it's the jurisdiction of this body to hear that type of appeal. One thing I would note, going back to the very, very first code section that Mr. Phelps referred to, it says that, let's see, municipality enforcing the Michigan Single State Construction Code can issue a building permit, and here's the statutory language, if the application conforms to this act, the code, and the requirements of other applicable laws and ordinances. Our position as a township is that the fire code is one of those other applicable laws and ordinances, and that under the terms of that ordinance, it's the fire district as opposed to it's the fire chief as opposed to the building official that interprets the fire code. And for that reason, the building official is able to decline a permit if the fire chief has not issued his approval. Notably, and I think the building official referred to this in his comments, the township building permit form has a number of checkboxes. And one of those checkboxes is whether the application has fire official approval. That's been a requirement for as long as I've been township attorney. I think that form goes back quite a while. And this particular application does not have fire official approval because there's no approved water supply as determined by Chief Janik. And that's why the building department's withholding the permit. And our position is that they're welcome to appeal the fire chief's determination, but it should be appealed to the fire district. If the fire board of appeals reverses Chief Janik, then I think that we're ready to issue a permit immediately. I think all the other requirements are met. And, the decision could potentially be reversed that way. That's basically our position as explained in the memo. If anyone has questions, I'd be happy to try to answer those.
And I don't want to interrupt, but I'd be happy to respond to that if that's all right. Hearing no objection, I will proceed with a couple quick comments. It is true that we have submitted an appeal that was suggested by the township in parallel with this to the fire district. We've made repeated efforts to try to come to some sort of resolution, and that was viewed as, in fact, by Nick himself. Why don't you appeal that to the fire board? And that's fine, and we've done that. The fact remains that that is not a statutory body. It does not have any statutory standing under the construction code. This body does. And ultimately what the issue is that the building permit is not being issued. And it doesn't matter what the reason is. The statute is clear. If a building permit is not issued, then it is deemed denied. And if it's deemed denied, it can be appealed to this board. So we're doing exactly expressly what is provided for in statute. To get a building permit, this is our relief. It's to go to the Construction Board of Appeals, and it is for you to determine whether it should be issued or not. We all understand that the reason they're not issuing it is because the fire district objects to it. But ultimately, whether that decision by the building official in the township to defer to the fire district, that you need to make the determination of whether that is correct or not. The fire district is not the last word, and the Fire Board of Appeals, which is created locally, that is not the last word either. And quite frankly, this is a process. Obviously, we hope that we'll get some common sense will prevail here, and we will be successful on this appeal. But this is subject to further review, and it goes through this body further. There are yet other appeals and legal review that can take place. So this is an important process, and it is not one that's intended to be just deferential to. Why are we even here? Why are you folks even appointed to this board? Why are we having this hearing if not to actually give some substantive thought to the issues before you? So with that, I yield the floor back. Thank you.
Nick, do you have a response to that?
And I guess just an answer to the last question. If this was an appeal with the underlying merits relating to any of the other codes that are adopted statewide, certainly wouldn't be objecting to this board making those determinations. If this involved interpretation of the residential code or the building code, electrical code, or plumbing code, those are squarely within the jurisdiction of this body. It's just the substantive arguments being raised here are issues that township ordinances have delegated to the fire district. I agree with Mr. Phelps that this board has jurisdiction to review the issuance of a building permit. That's clearly by statute. But the tricky part here is that the ordinance in question, and again, we're allowed to condition issuance of a building permit in compliance with ordinances. The ordinance in question here specifically delegates this question to a different body. To first the fire chief, and then appealable to the fire district. So that kind of makes this a unique situation as compared to the typical appeals that this body would hear. That's how we see the roles being divided between the two boards. Again, this board is free to disagree, but that's my recommendation as township attorney.
Hey, Nick, this is Jason Dedick speaking. is it determined that these particular sites are individual building sites and not a part of a subdivision or a PUD of any sorts? And has the health department, if there's no municipal water there, has the health department issued a well and septic permit for this project?
I don't know the answer to whether a well and septic permit has been issued. In terms of the question of whether it's a development or not, I can't really speak to that either. I do know, I've seen the correspondence from the fire district saying that that's their interpretation. But one thing I would note is that, I don't believe that the provisions that the fire district is making its determination on refer to developments at all. I think, I'm not exactly sure where that distinction between development and non-development is coming from. I don't believe that's actually part of the International Fire Code. I hope that helps to answer your question.
Yeah, I guess I'm just a little confused about the example that was shown for Heron Bay. I'm just trying to determine what the difference is.
So I'm not entirely certain what the difference is. One thing I can say, and Mr. Phelps or someone referred to this earlier, back in, I believe, prior to 2018, the township had a provision in its ordinance adopting the fire code that made an exception for single family houses. It said, it was the building official's comments where this was referred to. That provision basically said if it's a single family house, not part of a larger development, then the International Fire Code doesn't apply. And that allowed the building department to issue building permits without going to the fire code for each new house, going to the fire department for each new house that was proposed to being built. That has now been repealed. Now all buildings in the township are subject to fire code review. So if that's the single family exception that they're referring to, that has not been on the books for at least a year now. The timing of those letters makes it a little bit confusing as to whether that's what they're referring to or not.
Okay. Thanks, Nick.
Well, yeah, and I'd like to respond to that because it's actually not confusing at all. You have the letters, they're dated, and that this issue about Heron Bay, and there are others. We attach many of them. That was just one example. They're in your packet. That has nothing to do with this ordinance that was changed. I don't know when he said 2018. As now, currently, July of 2020, the fire district was granting these quote unquote single family dwelling exemptions to other single family residences in the township. And the distinction is that in the fire district's mind, that this is a development because there are multiple lots that were the result of multiple land divisions. So that it's just that simple. That's their subjective belief that it is quote unquote a development. I'm surprised and disappointed to hear Nick say, not acknowledge to your question that this was a land division. Simple. There's no debate about that. So why make that an issue? It's not a PUD, not a site condo. That would be obviously documented in this packet if that were true. It is what I said it was. It's a lot division, single family, lot of record, just that simple. And these other lots are being granted this exemption, which is just simply a subjective exemption from the fire district. Because in their view, those are not developments. And therein lies the problem that this is not really a code problem. It is a problem of personal perspective and subjectivity on the part of the fire district, which is, I hope we all know, is not the way any code is supposed to be administered. There's supposed to be objectivity and clear standards. When the voters buy a lot and spend money with the expectation of building a house, they have an expectation that they'll be able to do so without shouldering the burden of a public utility extension. The answer to your other question, your first question, was about the health department. That was approved, and that is in the stack of materials that we submitted. I just had it, now I've lost the page, but yeah, there's various Allegan County Health Department documents, but the health department did approve it. It was slated for on-site water and sewage disposal. So the typical requirements you would imagine in a non-municipal water setting, those were all gathered and submitted as part of the building permit process, and is indicated by the building official that it would have been issued but for this objection from the fire district.
Thanks, Aaron.
Well, do the members of the board have any questions of either attorney?
No, I think those were my question. I'm just trying to digest it all. To try and figure out what's going on here exactly, but I think I'm getting the picture here.
You'll see on page 28 and 29 of your packet, there's the Allegan County Health Department document, permit for on-site water and or sewage disposal, and it's got a little schematic, drawing of the well and all. These were always supposed to be serviced by private well, and that was the premise of the submission by the builder to the building department in the first instance.
Yeah, I do have copies of those documents. I'm not sure if I have a copy of the water well test, which is also required for volatile organic chemicals. Like I said, I did not accept the application. It was given to Michigan Township Services when I was on leave due to illness. Do the board members have enough information to make a decision at this point? Or is it still up in the air?
Do we hear the fire department side of the what their view is on this? Is that, again, I'm very new to this and I'm not sure the correct protocol.
Well, that's why they're going to the other Board of Appeals after this one.
Okay.
See, my issue is the conflict that I have between the prerequisites that the township has given me in order to facilitate issuing a permit, and yet what's holding me up is not in my control. Was the board ready to make a motion of any kind?
Chuck and Bob, what are your thoughts here?
This is Bob Firmus, if I can weigh in. I would say, without the fire department's, we'll say, side of this, I would say we give them adequate time hearing to have their side. We're all hearing the construction side of everything, which makes sense that this is truly just a fire department, fire code issue. Definitely say that they would at least have to have their side of the story heard.
Right.
Yeah, this is Charles Carlson, and I kind of agree that we're the wrong board to go before. This is clearly a fire code issue. I've been on construction board of appeals before, and usually people come to me or to the board for, to appeal the construction code, not the fire code.
That's good.
I think it's unfortunate, and I sympathize with the Bodishes, that it sounds to me, because of the fire code, that they have there are unbuildable lots in the township, which is not a good thing.
No.
And I think that that's where this discussion needs to be, not here with this board. I would be interested to know why. I work a lot with the fire department, and I don't know how to instruct my clients or direct my clients, because there's a lot of confusion, probably because the ordinance was changed, and then, it was changed in 2018, and then it changed back since then, or something like that. So there's a lot of confusion as far as what, how to address fire code issues, as far as driveway length and fire hydrants and ponds. But this is not a construction code issue. It's a township and fire department issue.
And that's where Al's saying that his hands are tied, because he'd love to write the permit right now. However, our township requires all of those sign-offs, if you will, electrical, mechanical, plumbing, fire department. And I think that's kind of where Nick was explaining it as well. Yeah, it's definitely a tough pickle here, that's for sure. But I agree, Chuck. I think that the grievance or the complaint is definitely with the fire department and not the building official.
Right. I mean, Al says that he's ready to issue a permit. I mean, there's nothing wrong with with what they want to do within their lot. There's nothing wrong here. They got the sewer, the septic permit, they got the well permit. There's
I even saw the driveway the driveway permit was also approved. I was just looking through the packet.
Right. This is an issue outside of their property, and I don't think, I would love to help them, figure that one out, but
Right.
This is not the place to help them.
Is Nick still with us?
Yes.
Is there
Yes.
any way this board can table this until the fire board takes care of their appeal?
Yes, you could. You could. So I'm not sure if they're going to be actually addressing their appeal tonight. I think they have a meeting scheduled, but my understanding is last time they had one of these, they had a meeting and then scheduled another meeting. So it could be a while before they actually decide theirs. Actually, I believe we might have statutory requirements of when we are required to act. Hold on just a second. Let me check to see what our statutory language is.
I thought it went to the Construction Board of Appeals or the Construction Code Commission, I'm sorry. After this.
It
Unless
does.
they decide to go to circuit court after this.
An appeal from this board goes to the state, to Laura, as opposed to circuit court. I'm just checking to see if we have to make a decision within a certain number of days from the application. Just a second, I'm looking through the code here. It might take me a minute.
I don't want it to get into a hysteresis loop of some kind where we would take the decision and put it off, and then all of a sudden they decide to put it off, theirs off too.
Right.
This is not helping the voters at all.
My memory is we have a certain amount of time, but I'm trying to find the language in the statute.
Well, I know if the Board of Appeals didn't react to a application, it would have been denied after 30 days.
Oh, that's correct. Yes, it's 30 days. So if this board has to make a decision within 30 days, if you were to table for longer than the 30-day period, then it would be considered an automatic denial. So practically speaking, we really can't wait too long for the fire board to make a decision. I can look and see when the application was submitted and see what our drop dead deadline is. Let's see. And maybe Mr. Phelps might have that date at the ready.
It was submitted 30 days ago.
Yeah.
Exactly 30 days ago?
December 11th.
Okay, wow. Okay. No, so tabling really isn't, the effect of a tabling would be, it would have the effect of a denial.
Yeah. Well, I don't know what to tell you guys at this point.
Yeah, I mean, this is Charles Carlson again. This is kind of a big pickle for me as well. You know, I don't think that I can, you know, accept or you know, this is like, again, this is not a construction code issue. If, you know.
Sorry, I don't mean to interrupt. This is Jazzy Bodish, and I just, I feel like we've been kind of sitting on the sidelines quiet for a long time. And as you can see, we have a 6-month-old, and this is just getting to the point where it's really frustrating and confusing for us because we don't understand why we're the ones getting the brunt of whatever is happening. There are so many other properties that didn't have a review that were approved at the same exact time that ours was denied, that are no different than what our home is, literally no different. And this is supposed to be our first home. And this has been the worst experience in our lives. And I just wanted to say that the fact that you think this doesn't have to do with you is so frustrating to me, because if we don't have you to come back on, then who do we have to go to? I mean, yes, obviously we'll take the next step and we'll keep spending our time and our money trying to get this figured out, but it's just really frustrating and unfortunate to feel like nobody is hearing us and our side, and there shouldn't even be a side. It's facts. It's clear. Ours is no different. Just like Mr. Dedick said, we are a land division. We are a piece of land. We are not a subdivision. We are not a PUD. None of those things. We bought a piece of land that we wanted to build our first home on, and that is the case. We don't understand how we are the only home, apparently, that's not a single family dwelling that doesn't get that exemption. There are literally 5 others that were approved. July 23rd, 6573 Karen Bay approved. Is approved and has a single family dwelling exemption. April 17th, 2020. 3144 Red Oak Drive. November 14th, 2019, Old Owl Drive. November 15th, 2019, Old Owl Drive. December 6th, 6042 Riverside Road. It's just, we don't understand why we are being singled out for this. And honestly, there's no point in waiting to hear what the fire board is going to say, because they just keep going against us for whatever reason that they have. We don't understand. I mean, there's literally been all these other properties that they have either just given into or they didn't even have a review at all. Thank you for your time, and we appreciate you considering this, and I apologize for the emotions. It's just been a really, really long time dealing with this. And like I said, we have a 6-month-old. We started this when I was pregnant still, and it's gotten to this point. Like, we 100% hoped and expected to be able to celebrate our daughter's first birthday, the 4th of July of all days, in our new home. And we're highly doubtful that that will even be an option.
You know, Jesse, this is Charles Carlson again, and I don't understand. I feel your pain, and I have a ton of questions for the fire department as well. I don't understand. I mean, you have a house on 66th Street, which is just a lot. This is not a development. It's along a public road. It's not even a private road. Your driveway isn't 150 feet long. There's going to be a huge pond in the back. And there have been applications that have been approved by the fire department. I don't understand why, I have a lot of questions for the fire department as well. I do.
And again, I'm not sure of the legalities or anything here, but is it appropriate to have a representative from the fire department speak right now? I just think that, to me, there's just so many, we've heard this side, we haven't heard the fire department side. So I don't know if it's appropriate to have Chris get on, and I always have great conversations with Chris or even Greg.
Right.
I'm just really confused as to why.
I agree, Jason. It's like, I work with the fire department all the time, and it's my job as, to protect the health, safety, and welfare of buildings and their occupants. And
100%.
It's like, I don't want to make a mistake here if this is a huge violation of the fire department. I mean, but I don't understand. First off, I don't understand why somebody that has a piece of property in the township is required to install public utilities off of their property.
Right.
But this is, so there are a ton of questions, and I'm frustrated as well. I feel the Bodishes, I sympathize with them. But I don't want to make a health safety issue mistake.
For sure. And I totally agree.
And I see Greg is on.
I saw Chris and Greg on, so I don't know. Again, I don't know if
Greg has showed up, so I'm gonna.
Jason, do I have your permission to try to make some comments, answer some questions?
Yeah, Greg, I'm just really confused. I think we definitely need a little bit of clarity from both sides here.
I feel everyone's pain, the Bodishes, everyone, Al, Chuck. This was not meant to be punitive in nature. I think what we have is we have some projects like Old Owl, Heron Bay. We never reviewed those projects. Things I think are taking out of context. They clearly have been. We saw a site plan for 13 homes. and we based it off of there were 3 or more houses off of that site plan of construction of potential of the 14 houses. That was the basis. When you cherry pick plan reviews, like for Heron Bay, I've been here 20 years. I never reviewed Heron Bay as a subdivision or project. And I'm sorry for the Bodishes for the misunderstanding. We've never made any one house extend a water main. We have gone by the premise, and I think there's some experience with Jason, with Charles on, we've taken the premise since 2008 when there's 3 or more houses within that project. And I think what clouds and makes this confusing for all of us is when you start using land divisions and lot splits, it gets technical in nature, and the fire code, fire doesn't discriminate on how you divide up the land. It's completely irrelevant. And our basis was seeing that site plan with 14 lots on it. When you compare it to Heron Bay or Riverside Road, we never looked at any developments there, any projects. So that's the difference here. It was a combination of components that led us to that. That's why you see that single family exemption. You build a house next to me on Silver Acres Drive, there's no water supply requirement. Riverside Road, Heron Bay, there is no water main. In this particular area, there's water mains on both sides of the property. Again, I completely see how the Bodishes feel like they're singled out. That is not the case. We're not trying to single out anyone. On the contrary, we're trying to say, isn't there an expectation of fire protection? No one offered fire protection to us until after the Board of Appeals was filed. No one. I ask you, how are we supposed to put the fire out? We have one house. Building permits are issued one at a time. They aren't issued in groups or clusters. That's why I think there's some personal things that are taken here. But the governing thing is we saw 3 or more houses, as we have followed since 2008, in what we call a project development. And that's where the water supply trigger came in. And that's how we looked at 66th Street, 3487.
Thanks, Craig.
Thank you, sir.
Well, I'll respond to that. I'm not even sure what to say other than that what I think that boiled down to is the fire district determined there were 3 or more homes in this area, and so they call it a quote-unquote project development, and they determined they wanted municipal water there. I mean, that is just nothing that was said had anything to do with the fire code. The fire code doesn't mention 3 or more homes, doesn't mention project development, and the fire department's not in charge of development. That's a township planning, a township ordinance process. There are extensive ordinances on that when you have PUDs, site condos, et cetera, and none of this is that. And the fact of the matter is the township did do these land divisions. They did do it without any requirement for extending municipal water. And the Bodishes bought their property with that, all of that information and that history in mind. They didn't lack any due diligence here. There were no requirements. It's a lot of record. And I understand that the fire district would like municipal, I'm sure the fire district would like municipal water and fire hydrants in front of every house, but that isn't what the fire code requires. It isn't what the township requires. The statement was made, how are we supposed to put out a fire? I guess you put it out the same way you put out all the other houses that don't have fire hydrants, and the same way you put out Heron Bay. And this idea that, oh, Heron Bay, blah, blah, blah. Look, the record speaks for itself. The documents are Exhibit G. The fire district did the same 18-point review for house after house after house. They're all dated April 2020, November 2019, July 2020, and time again, the fire district approves homes stating there's a single family residence exemption. Well, this is a single family residence that we're talking about. It isn't a development. And the fact that there are other people in the neighborhood that are going to build houses is irrelevant to the Bodishes. There's no common ownership. There is no developer to put this project together, this water main issue, which is what you normally see in a site condo situation. You'd have controls and requirements and approvals for that. And that's not what happened here. And I'll just, the board will have to make its decision here, but I want to reiterate that this statutory board is for denials of building permits. And there's been a little confusion here about, oh, well, this is a fire district issue and defer to the fire district. This is not an appeal of a code determination. That's not what statute says. It's a building permit. If a building permit, for whatever reason, is denied, this is the body you go to get it resolved. And then, as it stated, you can go to the state and elsewhere. But I want to make sure I've made it very clear, whether you ultimately do it or not, that the issue is if there's been a denial or a refused to issue a building permit, it goes to this body. And it doesn't matter if they said denying the building permit because they feel like it, because of a code, because of the fire district, because of anything. This is how you get those building permit issues resolved. And so we would appreciate a decision. I guess if you don't decide today, it's deemed denied anyway, so it'll move one way or the other. But the idea that this isn't the appropriate forum just isn't consistent with the statute.
Hey, Greg, are you there?
Yes, sir.
Oh, there we go. Obviously we're all, I believe at the end of the day, we all want to see a resolution here for sure. I know we all want to see the Bodishes be able to build their home here. So I'm just curious, does the fact that they have that big pond behind those lots, those so-called lots, does that help out at all?
We don't know. What we think is the water level is too low from the grade. That's head pressure, Jason. We can't suck up to that. Plus the engine would have to be at the pond. We've never seen any access. We had a plan submitted to us that showed some hydrants. And this is what we were hoping to work out. In between this, it was submitted after the appeal was filed, and we got a plan for hydrants from that pond water supply with not enough detail. So we sent it to our engineer, and we did a review on it and sent some questions back to Mr. Van Horn to answer. We haven't yet to get a response from that. But we even considered that. We even said, we'll consider some wells. Mr. Van Horn suggested a couple of wells that they would put together for enough fire flow for it. We were to consider that. But I think the timing is such that everyone is under pressure here, including the fire department. We've got in the midst of immunization of Allegan County. So we have a lot of things going on as well. And what we tried to do is, we were receptive to looking at alternative water supplies as an option, but we didn't get enough information to consider drafting out of the water. You can't just suck water. Hydraulically, it doesn't work. You only have 14 feet ahead. So we asked Mr. Van Horn, how far down is the water level? We'll need an access road. Is this designed to a standard? This is what's typically done, like a pond water supply is built to a standard. And those were the questions that we were trying to get answers to so that we could come to some sort of conclusion that there would be an acceptable water supply there, and that permits could then be issued and we could work out the details. We didn't have enough information on that pond water supply to consider that. Does that answer your question, Jason?
Thanks, Greg. Yep, it sure does. Thank you.
Greg, this is Charles Carlson again.
Yes, sir. Yes, sir.
To me, I understand that this is not a development. It's more of a lot split along a public road. But then that's brought some issues to what you do. And I think it's a shame that the township and the fire department, as close as you guys are not working together to, when things like this happen, when somebody does buy a huge piece of property and split it. I think it would be a totally different issue if there was a road that went inside of this, in the middle of this property, because then I think that Mr. Van Horn would have been required to bring it up to code. But what is the difference between a lot on 66th Street along this road and a lot on, out in the farmlands out on like 100 and, or 64th Street or something like that? I live on 64th Street and people are building houses all up and down that public road, and nobody's required to put in a pond. Nobody's required to, put in a fire hydrant because it's a public road. And I don't understand the difference between this and quite frankly, this needs to be discussed in the next meeting, I think. But I just, what is being done, and I think I'd love to help establish that. But what is being done with a working relationship between the township and the fire department so that something like this doesn't happen again? Because I think that this is a horrible shame.
Well, Chuck, I agree. The township's been great working with us. As you know, when this was split, this land division occurred in 2018. All that was approved was land divisions. We were not involved in it. We read about it in the paper. I'm not going to argue with anybody. When you get a site plan that shows 14 lots side by side, we don't know what would preclude us not to consider that a development. Forgive me, but that's the way we looked at it. Whether it's on a private road or public road, it's irrelevant with fire suppression. What we had hoped to do is we would hope to find if Mr. Van Horn, so I guess I'm confused if Mr. Van Horn is providing the water supply, where does that fit into the single family dwelling aspect? Just a question. So we were hoping we could come to some sort of conclusion on, hey, we can work with this plan if we had more information. And that's where we're at. We were hoping to have some sort of answers on, could we use that pond water supply? Where's the pump? We don't know how the water's even going to get up there. We're not using our engine. We don't provide engines for fire suppression. We've got enough to do. And how do we even get to the pond? So it's a number of items, I think, Chuck. When you start taking a standalone house, that's one thing. We looked at the site plan that was given to us. That was the trigger, the site plan. So that's the difference between a house on 64th Street.
Hi, this is Tyler Bodish. I just wanted to chime in on just a couple things. One, I mean, the site plan was turned in, I believe, in 2018. So I guess plenty of time to rectify all of that. I guess my point is that all of these other ideas and coming out and how the water is going to get there and how a fire is going to get put out and all of that, I don't understand what that has to do with our building permit in particular. Whatever you guys want to do to figure out how that happens in water and where it comes from, I just think that based on the other approvals that have been given, that it's only fair to follow in that same guideline, and that anything else that's past that, as far as water supply and how fires get put out, that has nothing to do with my wife and I and the house that we want to build. And I just wanted to kind of make that clear. This has nothing to do with us. We're just laying out what we found, and we want to build our home. I mean, we've been 4 months sitting here with a hole in the ground when that site plan was turned in 2018. So that's all I have to say. Thank you again for everyone for your thoughts, and hope we can get something figured out. Thank you.
Hey, Bob, you got some thoughts, comments?
I mean, I agreed with, the Bodishes, they have a home proposed that meets and checks every box for a construction project. But obviously the fire district and the fire department, that's another, we're a construction board. That's what we do. And as construction, there's no issues with this construction of this project. But now having it as a fire district, the fire department, they have their codes and they way that they have to govern and protect everything as well. So, I think as we're all kind of going and pointing towards that, that appeal to that fire district meeting that they're going to have, I agree that that's kind of the road that this needs to go on.
Yeah.
I agree. I mean, if this is Charles Carlson again, if the issue could be resolved with the fire department in this situation, I would have no problem. I mean, you wouldn't even be before us.
Agreed.
There would be no reason to come to us. So, I mean, I think, I don't know how to address, because I mean, it would be an automatically acceptance. No reason to appeal if it wasn't for the issue with the fire department. So, I mean, if we deny it, what's the point of denying it? The appeal. Well, I don't know. I'm kind of like, to me, it's I can't grant the appeal because it really doesn't have anything to do with what we should be appealing.
Right.
Nick, are you still on?
Yes.
What would the ramifications be if this board decided to allow the permit? Any ideas?
I mean, I guess allow on what basis? If the board were to, let me take that in two parts. First off, Mr. Phelps referred to a variance provision in the state's Construction Code Act. As I read that provision, it only allows variances from the state adopted codes, not the fire code. So it uses that term code again, which is defined in the statute as meaning building, residential, plumbing, and electrical, not fire. That being said, I mean, if this board were to kind of grant the appeal to essentially overturn the fire district's determination, a permit could be issued. The fire district could potentially appeal that decision. I guess I haven't given that a lot of thought. I would think they would potentially be able to do that. And again, appeals from this body are taken to the Department of Licensing and Regulatory Affairs, and then I think are ultimately appealable to
Code Commission.
Right. I guess that would be the consequences of granting the appeal. The effect of denying the appeal doesn't mean that a permit would never be issued. It would effectively be deferring to the fire district in their processes, their appellate processes. So as we've noted, that every other requirement of the permit is met. So if the fire board were to reverse the fire chief's decision or to grant some other type of relief, the township could then issue the permit. once that determination was made. So a denial of the appeal is effectively a deferral to the fire board.
And in the long term, I'm sure there's probably going to be some issues with other builders in regards to the fire department's decisions. And we may go back to where we ended up back in 2018 when they took that portion of the code out.
So one thing I can say is that this is at least the second time that this issue has come up. There has been within the last year another appeal to the fire board of a fire district interpretation as to the water supply, and that that appeal was never brought to the Construction Board of Appeals. It was brought directly to the Fire Board of Appeals, and eventually the fire district and the developer resolved that. I'm not exactly sure what the resolution was, but
yeah, that was Boxcraft.
For context, this isn't the first time this has happened.
Right.
Yeah, I feel we're in a rock and the hard place here. You know, if someone were to come to apply for a permit on the west side of this street on a piece of land that was not divided by Mr. Van Horn, what would happen there? You know, and that's, you know, obviously, and the fire department knows I take them very serious, and I work very well with the fire department. I'm just looking at it from both sides here. And, you know, obviously the health and safety of families is definitely number one. And that's where I want to see a resolution sooner than later here, so the Bodishes can get going here. But again, I gotta, unfortunately, we've got to tread lightly here, and, you know, yeah, I don't know if there's any way to make everyone happy, but I just, we've got to get a resolution going here. And I don't know if that is at the Fire Department Board of Appeals right now. But I think we've brought up some valid points here today.
I think that was a really good question about the west side of 66th Street. What would happen with that?
Again, you know, I'm looking at it because I don't believe this is a registered PUD, or, you know, it's a lot of lots right next to each other, and I get that. And I don't know if Mr. Van Horn was required to do anything to split this land up. I don't know that side of things. I'm just trying to bring things up to help try and get resolution here is all.
Well, I reviewed land divisions in the township for almost 20 years, ever since March 31st of 1997, when it was first incepted. And over the course of that 20 years, I've divided a lot of properties along a public road, and there has never been anybody calling that a development.
This is Charles Carlson again. Is the issue here that the township is not calling this a development, and the fire?
Chuck, can you say that again? I think you were cutting out, and at least I know I lost you.
Yeah, I did too.
Or I think you're muted now, Chuck.
All right, so sorry about that. My question is the issue here that the township is not considering this a development and the fire department is? Is that
that's how I'm seeing it, Chuck. You know, that's how I'm seeing it, and that's why I'm trying to get this information out. And I believe I asked earlier on whether this was a registered PUD, because it doesn't sound like there's an association. I don't think they pay annual dues, you know, and that's like, to Al's point, he's done land splits along these roads for so long, and they're all just individually sold lots, not a part of an association or a PUD. So, and I think that's where, but I understand Greg's point too, is you see a lot of homes, but again, I don't know what the code or the law says when it is not a registered PUD.
Right.
We've all got our personal opinions here, I'm sure, but again, we can't really go with our personal opinions here. I think we've got to have the facts and make decisions based on that.
Right. I agree. I mean, I think that this conversation isn't really appropriate for this board, but I am just bringing up these ideas and these thoughts to help the Bodishes and to help Greg. I mean, I don't see, there's got to be a resolution, I think, between the township and the fire department as far as how to handle this. And the developer. I mean, this is not a development, but the person that originally split the lots, when that happened, there should have been some conversation between the fire department and the township. And I think that that's where, things are falling apart here, is because there's not that. And I just hope that I'm helping the Bodishes by bringing this up.
I agree. And I think that that's, in a roundabout way, why I've been bringing up my points is I agree with you, Chuck. I think that it is a more of a fire department issue here. And I hope that us discussing this today has kind of brought up some points and to help move towards resolution sooner than later, so we can see this home move forward. Not to mention, I'm sure that those lots are desirable. It's beautiful. It's a great location. I have no doubt we're going to see another building permit here real soon for another one of those lots. I believe most of them are already actually sold. So, unfortunately, the Bodishes were the first one on the block here, but there's 14 more lots that have got to have resolution here.
Right.
I appreciate that, Jason and Chuck. I wanted to answer one of your questions was, is the problem here the township doesn't think it's a development and the fire district does, and I do think that is essentially what this boils down to is there were no requirements. It's not a PUD. I mean, different times we can say that. These are just land divided lots, and there may be multiple of them, but it doesn't change the legal effect that they're lots and they're mostly sold. And so now who is supposed to pay for all this municipal water, and how is that going to be organized? Nothing's ever been done like this. You don't have an informal agreement between a bunch of random lot owners to extend municipal water. I mean, if this were done in a site condo PUD context, there would have been, all of this would have been worked out ahead of time. There would have been a contingency to approval. All the people who bought or were prospective buyers would have known all of that. And there would be a system or an association, et cetera, that would develop, that would pay for that, would extend the utility. The cost would be built into the lots. None of that has happened, and none of that can ever happen. Now, the lots are sold. People paid what they paid for their lots. And here we are. And the fire district can say all it wants that it's a development, but that's a peculiar development that was approved by the township without any requirements for any of these things that we're all sitting here talking about now. I mean, the reality is there's no citation to any authority that this is a development, no ordinance, no zoning, nothing in the fire code, nothing says that when you have 3 or more lots, you get municipal water. And if you have fewer than 3 lots, you don't. And it is just it's a subjective desire of the fire district. We all get it. All things being equal, I'm sure the fire department wants those fire hydrants, 2 feet apart. I mean, that would be even better. But that subjective desire cannot trump the objective rules that are in place. So it is frustrating. I mean, the hour draws late here, and so I guess we need to wrap this up. I think a lot of great comments from the board, and I appreciate that. But I know the Bodishes, when we get off here, they're the ones that are going to be left with a vacant lot and needing a place to live, and they're not going to have it. And what's become clear here in this conversation is that there is no specific rule that we've talked about for the last 2 hours that requires them to fund this project as a lot owner.
Well, this is Charles Carlson again, and I agree. I think we need to wrap this up. I think the discussion, I carried on this discussion because I just wanted to help the Bodishes understand the predicament that we're in. So many times people, as an architect, so many times people come to me and they say, how do we work around the codes? And quite frankly, Greg and the fire department and the building department are all trying to protect people from the, protect people, their lives, their safety. And you don't want to work around building codes or fire codes. They're meant to protect you. I think what the Bodishes need to do is work with the township and the fire department to resolve an issue, or this issue, so that everybody is safe. The fire department's trying to protect you guys. And I'm sorry that it's, maybe I don't know the answer, but like Jason's right, there's a ton of lots up and down there that you're all gonna have the same issue. So if there's something I can do to help resolve that other than this board, I'd be happy to help.
Thanks a lot, Chuck. I think we've got to wrap this up. And again, I think that my fingers are crossed that the meeting with the fire department, I hope there's a resolution with that. Because again, I don't believe that it's this board's place to overturn the fire department's decision here.
I agree with Jason 100%. I mean, we are a construction board, unfortunately not a fire board. And I would say that this is as sad as it is to say, a 100% fire board issue. And there's really, if there was something construction wise, that's why we would be on that board for construction. But I don't think we have the power to overturn a fire board's decision or even appeal it or disagree with it. I don't think that is our place to judge, or puts us in a bad position as well. I mean, I totally feel for the Bodishes. I see their situation. It's unfortunately, it's just not a black and white case of if it checked that box, which it did construction wise, no brainer. But yeah, I don't know. It is just between a rock and a hard place decision, and what's the right way to judge this or govern this, or how to even explain it.
I think that's kind of the point, that it's not black and white, and it's not following the same statutes that the other ones are, and just kind of being being cherry picked out there as the one strip of a public road that has 14 lots on it as the only one that I don't know of another one, or if anybody else does, please correct me, that has to have these requirements. And I also think that, that is the reason you guys are on this board, because what happens when we go to the board of the fire board, and what happens when they say no? Or what if they say, oh, we have 30 days to do this, now we're another 30 days out, then they come back and then they say no, then where do we go? It's like we bought this lot, we have most of our money into this build that is now sitting on 4 months, and we're we have to move out of another apartment in March and find another one. And then, who knows at that point where we're at. And I think that that's the confusion here is, I mean, from my understanding, that's the exact purpose of this board, is we're being denied a permit for something that we feel, and I believe, a lot of other people are seeing what's laid out here as for a reason that's not consistent. And that's why, we called upon you guys, is because we're not getting anywhere. I don't believe we're going to get anywhere with it, and it's just going to keep dragging out and dragging out. That's why we came to you guys, because you do have the power to overturn it. And we hoped that you would see the facts and everything here. And I understand that nobody wants to step on toes, and we all live in a small community. But I mean, this is, everything's laid out right here. It's pretty plain and simple that, that we're not getting treated the same way as other builds within the last year have. So I would like you guys to consider that if you could. Thanks.
I think it's time that someone make a motion.
Does anybody make the motion, or does it?
Anyone, yes.
Unfortunately, it is, from my education and from what I know of the building department and the fire department, I have to deny this appeal, or I motion to deny the appeal.
And I think there's a sample motion if you wish to use it at the end of the attorney's letter.
Sure. I motion to deny the appeal and affirm the building department determines not to issue a building permit until the fire district certifies compliance with applicable fire code requirements. Unfortunately.
Is there a second?
Jason.
Okay, I'll say everyone's name. Please either vote yes or no to the proposed motion unless there's any other discussion on the motion. Hearing none. Robert Firmus.
My motion is no.
I'm sorry, for clarity, are you voting no on the proposed motion?
Yes, I'm voting no on the proposed motion.
Thank you. Chuck Carlson.
Of course I do. Well, yeah, I'm motioning to the appeal, or I don't know how to answer this.
Correct. So Mr. Carlson, you made the motion. Now you're either voting yes for the motion or no for the motion.
That's for the no motion. Yeah.
Thank you. Mr. Dedek.
What was that? I think there's some confusion here.
Yeah, I would like to.
We've never done this before.
Okay, sure. No, that's great. And I appreciate you guys saying that, because we'd much rather, get everything clarified and do it right. So just to clarify, Mr. Carlson made a motion to deny the appeal and affirm the building department's determination not to issue a building permit until the fire district certifies compliance with the applicable fire code requirements. So someone made a motion, someone seconded a motion. Now we need to vote on the motion. So you all get an opportunity to vote yes to support that motion or no to deny that motion. You can deny the motion and make another motion if you'd like. You could support that motion. That's the motion that then stands. I mean, you all can discuss more. You all, at the end of the day, as the Construction Board of Appeals, you guys get to determine the next step. So making the motion is the formality of that, and then you also have to vote to pass or deny the motion. Does that make sense?
Yeah.
Okay. So I don't know if this is how you would like to proceed, but Mr. Carlson, would you like to make a motion?
Hey, do you want me to make the same motion again?
That's up to you.
Okay, I motion to deny the appeal and affirm the building department's determination not to issue a building permit until the fire district certifies compliance with the applicable fire code requirements.
Thank you. Does the motion have a second?
Second.
Thank you. Is there any more discussion on the motion? Hearing none, we'll go ahead and vote. So you're now voting either yes or no. Robert Firmus?
And a yes is to deny.
Yes,
Yes, yes is to deny the appeal.
Well, yes to Mr. Carlson's motion.
Thank you. Mr. Carlson?
Yes.
Thank you. Mr. Dedek?
Yes.
Thank you. The motion passes 3-0. Al, I'll turn it back over to you.
Okay. At this point, I guess, if there's any other business to come before this body,
The agenda outlines an open board report. So if there's any member of the Construction Board of Appeals that would like to make a report or any comments, this would be an appropriate time to do so. Otherwise, if you have none, we can move on to the last public comment session and adjourn the meeting.
Griffin, I guess I just like to, I feel unfortunate to be placed in this position, to be honest with you. Obviously I'm in the construction industry and it brings me great joy in doing what I do and building homes for people. And I guess I'm just saddened with this predicament. And so I just, and that was it was a tough decision. And I know it was for Charles and for Bob right there. So I'm just putting it out there. I just hope that the fire department did, listen to our points. And I really want resolution there for the Bodishes. And I just hope tonight's meeting goes in a positive direction and not spinning the wheels. But as Chuck mentioned earlier, fire safety is definitely number one when it does come to construction. But there's also, options that can be introduced to make that happen. So I just hope that it's a good discussion tonight and a positive move forward. That's it.
Thank you. Mr. Carlson or Mr. Firmus, do either of you have comments you'd like to make?
No, I think Jason, I pretty summed it up really well for how we all feel, and it's really unfortunate. And Jason, what you said is how I feel too. So.
Yeah, I agree 100% with Jason and obviously Mr. Carlson as well. But I mean, obviously, I would like to just put in another 2 cents that obviously this isn't going to be the first project on this piece of property. Whatever's made from whatever the next meeting or appeal to the fire, this is going to be moved forward for the rest of those projects. So there's kind of a lot at stake. It is just one person, one lot, the Bodish family's project, but this is kind of going to set the bar for the rest of those the rest of those sites moving forward.
Thank you. Unless any of you have another comment to make, we'll move on to the last public comment period. Getting to the last public comment period, similar to the beginning of the meeting, please acknowledge yourself if you'd like to make a comment, and you'll be recognized. We'll work through everyone who would like to make a comment. And after that, I'll give one last warning to make sure everyone's had an opportunity to speak who would like one. And then we will, the construction board will have the opportunity to adjourn the meeting. So with that, is there anyone who would like to be acknowledged to speak to public comment? If so, please acknowledge yourself. As a reminder, *6 unmutes you if you're on phone. You can acknowledge yourself by raising your hand, waving, whatever you need to do to get my attention, or go ahead and unmute yourself. Seeing none, we'll do the last call for public comment. Okay, with that, we'll turn it back over to the construction board where it'd be appropriate for someone to make a motion to adjourn.
This is Bob Firmus. I'll make the motion to adjourn this meeting.
Thank you. Can we have a second?
Jason, second.
Thank you. We'll go ahead and vote. So Mr. Carlson,
Yes.
thank you. Mr. Firmus,
Yes.
thank you. Mr. Dedek,
Yes.
thank you. The meeting's adjourned at 5:01 p.m. Thank you everyone for attending. We really appreciate your time. Construction board, thank you very much for taking the time to hear this.
And I have to apologize to all members of the construction board that they thought they weren't going to have a hearing for 20 years.
That's how you lured me in, Al.